questions, we have Mike Holtz.
Well, good evening, everybody. Thank you for coming. Have a few opening comments, then answer your questions. Excuse me. As you know, we issued a statement yesterday pertaining to the status of one of our men's basketball student athletes, Terrence Shannon Jr. Terrence yesterday was arrested and charged in the state of Kansas. We have suspended him from participation in our men's basketball program. University, our athletic program, of course, take this matter incredibly seriously. I want to state unequivocally that we have zero tolerance at this university, across the University of Illinois system, and within DIA for sexual misconduct. It is antithetical to our mission as an educational institution to grow, develop, prepare young people. As I'll explain, we'll continue to demonstrate our commitment to this value through our policies, our actions. When we learn of alleged behavior of this variety, we will act in a way that is both timely and appropriate. At the same time, we also have to understand that we respect due process, and we understand that when allegations arise, especially allegations like these that are criminal in nature, the presumption of innocence continues to apply. I think it's important, before I get into the details of Terrence's situation, that I spend a few minutes talking about how we as an athletic program have prepared for years to handle a situation like this. We hoped we never would have to, but we wanted to make sure that we were prepared in case we did. Shortly after I arrived here in early 2016, we underwent a review of our risk management strategies. If you go back in time and think about the 2015-2016 window, there were a lot of challenges confronting athletic programs across the country. There were situations that were really unfortunate playing out at various institutions. As we studied those situations and trying to learn from what was happening there, what we could do to do our part to try and minimize the risk of those things happening here, a few key themes emerged. Number one, we wanted to be prepared in advance. Too often we saw institutions that appeared to be caught flat-footed when moments of crisis occurred. We wanted to develop thoughtful structure and policy. We wanted to remove DIA personnel, especially coaches, administrators, from investigative roles and from short-term decision-making roles. We wanted to be proactive and address situations early, and we wanted to communicate early and often with various campus personnel, including our chancellor and campus legal counsel. As part of that preparation strategy, we have adopted an approach with our student athletes where we talk with them at the beginning of every school year on a variety of topics about their experience as a student athlete at this university. One of those topics is student athlete discipline. And at that all-student athlete meeting at the beginning of each fall, I'm the one who delivers that particular topic. We talk about what we call the 3 tracks of student athlete discipline. I think it's worth a moment to touch on those. Track 1 is the legal system. And obviously, we've seen that play out here in this situation involving Terrence. The second track is one that maybe doesn't get talked about as much. It is operated by our university, the Office of Student Conflict Resolution. We refer to that as OSCR. They have the opportunity to investigate situations to determine whether students at large have conducted themselves in ways that violated the university's student code. And then track 3, which is where we spend most of our time, deals with potential misconduct that violates policy here within the Division of Intercollegiate Athletics. Each of those tracks, as we tell our student athletes, exists on a parallel and independently, although they do, in some circumstances, intersect with one another. I want to talk for a moment about that third track, the DIA discipline track. We have created a structure here led by our Chief Integrity Officer, Ryan Squire. Ryan has served in that role since shortly after my arrival. He operates completely independently within our structure. He has no oversight of sports or coaches. And among his many responsibilities, he is responsible for taking the lead on all matters involving potential student-athlete misconduct and discipline. Shortly after we created that position, Ryan and I worked together with a variety of offices across campus, including the President's Office, the Chancellor's Office, Student Affairs, the Office of Title IX, Campus Legal Counsel, and others to develop what is now our student-athlete misconduct policy. And I hope some of you had the opportunity to review that. We shared it in a link in the release that we issued yesterday. That policy does contemplate misconduct of all different kinds, up to and, of course, including the most serious of offenses. What I think is important from that process is that DIA is not an investigator. That is not a role that we play in any of these tracks that I discussed. We don't have the expertise, nor do we have the personnel to investigate these kinds of claims, especially as they become more serious and in some cases criminal in nature. Instead, we rely on the information that is gathered by our counterparts in this system, talking about, in particular, law enforcement or our colleagues across campus in the Oscar office. As we gather information through those entities, we have an opportunity to make decisions, more informed decisions about how to manage our student-athletes' participation in our program. In most cases, those processes, a legal process, a student conduct process, will ultimately resolve, and we will make a decision about a student's long-term status within our program based on that resolution. And so if, for example, a student-athlete is found guilty of a crime, then we will know, okay, well, he was guilty of this. What does that mean in terms of his long-term status in our program? The challenge with that is that those processes take time. They take a long time. They can take months. In some cases, they can take a year in order for them to reach their full conclusion. The challenge that we have, that athletic programs like ours face, is what do you do in that interim period? What do you do during that period between when you receive substantiated allegations until a process is concluded through the court of law or through the Office of Student Conflict Resolution? And that's really where our policy is designed to live, is in that intermediate period of time. The way we've chosen to approach it through our policy is that upon receiving sufficient triggering information, we will suspend immediately. And when we're talking about matters of serious misconduct, there are no questions asked. Once that happens, we then have a university conduct panel that is convened and will meet within 48 hours of the initial suspension. That panel exists independent of the athletic department, and it will determine, using the information that we have available at that given time, whether that suspension should remain upheld or should be amended or, in some cases, lifted altogether. The panel is populated by a member of our faculty at the College of Law. It is populated by one of our faculty athletics representatives. And third, it is a staff member from our Student Affairs office. All of these folks have been selected by the Chancellor and, again, are designed to exist outside of the realm of the athletic program. As the athletic director, my role is limited to determining when we have enough information to trigger this process. When do we, and in consultation with Ryan Squire, our Chief Integrity Officer, and as appropriate with our Chancellor, with our legal counsel, when do we have such information as we should start that process, which results in immediate suspension and then ultimately that conduct panel convening. So I appreciate a few minutes to talk through that process. I think it's important, again, in context, to help everyone understand the preparation that has gone into, of course, not knowing exactly that today would come, but knowing that the possibility of something like today could happen. I feel very prepared, and I feel confident in the decisions that we've made. With that, I'll transition and talk specifically about Terrence's situation. As you saw in the statement we released yesterday, we indicated that we had received some preliminary information about this back in late September. I'll talk more in detail about what we knew and when we knew it, but it was the collective opinion of myself and in consultation with others across campus, including the Chancellor, again, Campus Legal Counsel, that the information we had received was not such to pass the threshold necessary to launch our misconduct process. That stayed in that vein until just 2 days ago, Wednesday, December 27th. One last caveat before I get into the timeline. This is, of course, an active legal proceeding. We are very respectful of the process that the Lawrence Police Department has undertaken. We have tried to remain in that position throughout the entirety of this process. We have had no direct communication with the Lawrence Police about Terrence. All of our communication has been funneled through the University of Illinois Police Department, and they've been the intermediary for us as we've worked through this over the last several months. Okay, so going in terms of a timeline, late September, UIPD received a communication from the Lawrence Police that they were interested in conducting an interview with Terrence. The inquiry was light on details. We didn't know at the time whether Terrence was the subject of the inquiry or whether he might have been a witness to some other matter that had happened in Lawrence. It was very short on specifics. We immediately had a conversation with TJ about his weekend in Lawrence. I think everyone realizes he had traveled to Lawrence to see our football game, had spent the weekend there. He was very forthcoming with us, detailed his visit, but nothing he shared with us triggered any cause for us to institute any discipline or take any action. Over the course of the next several days, we learned that TJ was, in fact, the subject of the inquiry, but again, details remain very limited. We followed up again with TJ, still offered nothing additional. Around this time, TJ obtained his own counsel, who then began communicating directly with the Lawrence Police on TJ's behalf. In subsequent conversations, we did learn, again through UIPD, that the allegations that were being investigated seemed to be something that occurred in public in a Lawrence bar where TJ interacted with a young woman, and the allegation was that he engaged in some inappropriate touching of her in the course of that interaction. Everything that we received was verbal, informal. It was light on details. It was unsubstantiated. It was unclear to us whether Lawrence authorities intended to pursue anything further, what additional information they were trying to obtain. We weren't made aware of any specific charges that the folks in Lawrence were considering. As we evaluated the information we had, compared it to some of our prior experiences, we've used this policy on numerous occasions. We saw that we didn't have the same kind of information that we have used to initiate the process in the past, or we didn't have anything in writing. There was no written notice of allegations, no documentation. We didn't have a police report, and so we were looking to obtain something more than just the verbal updates that we had received from Lawrence PD through U of I PD to us. Throughout that process, as we obtained whatever information we did have, we shared it again with the Office of the Chancellor, the Campus Title IX Office, and University Council, seeking their input and thoughts on when the information we had was sufficient to, again, trigger implementation of our misconduct policy. And throughout the entirety of that experience, the unanimous opinion of all of those people was that we did not. We actually then went the extra step. Again, we knew what we needed in order to initiate the process. And we asked LPD through U of I PD for something more concrete. We asked to see a police report. We asked for updates with some frequency over the course of the weeks and months that followed, but nothing was forthcoming. I don't say that in a judgmental way. Again, understanding that Lawrence PD had their own investigation to run, we don't expect them to prioritize what was happening here in Champaign. But the fact of the matter is we weren't able to get additional information despite our requests to do so. That was the state of things as they remained until just 2 days ago on Wednesday, December 27th. I'll talk now a little bit about the last couple days things have obviously picked up pace, and a lot has transpired. Early Wednesday afternoon, I received a phone call from U of I PD indicating that they had a communication from the Lawrence police that they would be sending over a warrant for TJ's arrest. That warrant arrived mid-afternoon while the team was practicing, and later that night we also gained access to their police reports for the first time. Notably, this was the first time any of us had seen any formal allegations against TJ, any documentation related to this situation. It was also the first time that any of us were made aware that the charge in this case would be rape, as that term is defined under Kansas law. We'd never been, as I mentioned earlier, made aware of what charges were being considered by the people in Kansas, and we certainly were not aware that it might be something so serious as what was finally included in the warrant for his arrest. Immediately after practice, we pulled Coach Underwood off the court, had a chance to update him on the situation. Not long after that, we brought Terrence into the room. I delivered the news to him myself, talked with him about the situation, provided him verbal notice of his immediate suspension from the program. At the same time, U of I PD confirmed that TJ could present himself to the Lawrence authorities the next day. You then transition to the next day, yesterday, Thursday the 28th. We arranged for TJ to be transported to Lawrence by members of our staff. They left early yesterday morning, arrived in Lawrence around 11:30. Terrence presented himself. He was booked, posted bond, and I believe was released shortly after 12 o'clock. Our group was back on the road, returning to Champaign by 12:15 or so, and I got back to campus last night sometime between 6:30 and 7. In the course of the day yesterday, we also provided TJ with written notice of his suspension, formal notice, as we are required to do under our policy. Brad met yesterday morning with the team, notified them for the first time of TJ's situation. The meeting started at 10:30, led immediately into our practice, which started at 11. I did have the opportunity to participate in that meeting. I was impressed by Brad's message, by his tone. I was grateful to our team for their maturity, for their connectedness. And then last note about yesterday, for the first time, I did yesterday see the official complaint in this case. I know some of you have seen it as well. It was apparently filed against TJ on December 5th. We were not made aware of that filing, but in fact, one of our staff members retrieved it from social media last night, so we had a chance to view that for the first time as well. I mentioned Coach Underwood, probably a good time to talk a bit about his involvement in this throughout the course of the last few months. We made Brad aware of that initial inquiry back in late September. We kept him apprised of new information as we received it. We refreshed him on our misconduct process. Again, this is a process we've developed over time. We communicate about this extensively with our staff, but we reminded him of how this could work if and when we received the necessary information to trigger the process in the first place, up to and potentially including Terrence's suspension. But let's remember, and this goes back to some of my comments at the outset, the policy is designed to move our coaches out of the process altogether. And so Brad has been kept largely on the sidelines during this. We don't want our coaches conducting their own investigations, asking questions. That's not their expertise. It's not the lane that they should occupy. It prevents them and us from putting them in situations that places our university or questions the integrity of our process. So to be clear, it was not Brad's decision whether to suspend TJ or not. This is not a traditional, violation of team rules situation. Because of the nature of the allegations, the magnitude is reserved for evaluation by my office and the implementation of our policy. So I want to make sure we're clear on that. Just to wrap this up and then open it up for your questions, obviously an incredibly unfortunate situation on so many different levels. We've all enjoyed watching Terrence play this year. We've enjoyed seeing our team compete. But in moments like this, we have to understand that basketball must take a back seat. And we have an obligation here as a university to take allegations such as these incredibly seriously, which we are doing and have done. Sexual misconduct has no place on this campus or on any other campus for that matter. Our priority is the well-being of the people who are involved, and we'll handle the situation with great care, appropriate diligence, and concern. Just to reiterate one last time, all of us associated with Illinois athletics, the University of Illinois, the University of Illinois system, stand united in making sure that we provide a welcoming, safe campus environment to all of our students. We have no tolerance for instances of sexual misconduct. And with that, I will open it up to your questions. Please understand that my responses may be limited by, of course, the legal proceedings and the privacy of the folks involved. But with that, take questions.
Start with Doug, and then we'll go to Jeremy next.
Josh, just did the information about the incident that Terrence provided to you, did that jive with what you've seen on the documents provided by the DAA and the police department?
I don't recall saying that Terrence provided me any information about the incident.
Josh, you said you were in this inappropriate touching in late September, correct? Why was the DIA comfortable then promoting Terrence Shannon in the meantime?
Well, as I said, I think the determination for us is whether the information we had was of a level that allowed us to initiate our misconduct process. And in consulting with a variety of campus officials, we didn't feel like what we had at the time was enough. We had verbal information that had been provided through the intermediary of UIPD. In prior instances, we always had something in writing. We had something more formal, whether that was a written allegation, a formal notice of allegations, a police report. We had nothing in writing that was more concrete than some of the relatively limited details that we were able to receive through UIPD.
Go to Matt and then to Derek.
Josh, sorry, I'm over here.
Hey.
Is it accurate to suggest, based off the conduct policy, that where we are now is that the next step is that 30-person student-athlete conduct panel? Is that the next step for Terrence and this conduct policy at this point?
Yes.
Josh, within that, the construct of that panel and the process there, is it possible that a determination will be made on his playing status before the legal process plays out, or how does that chain of events work together?
It is possible. That's one of the reasons we designed the conduct panel the way that we did, was recognizing that these legal processes, or in the alternative, our campus conduct processes, can take a long time. And we don't always have the luxury of that time in making some of our determinations about a student-athlete's status. And so under the policy, our conduct panel will meet within 48 hours of the suspension.
Joey, up here in the front row.
Josh, obviously, given Terrence's role on your team, he's somebody that you guys put at the forefront of a lot of different things. Why were you comfortable knowing that you didn't have any paperwork to trigger the suspension, but knowing there was some sort of investigation to promote him the way that you guys did?
Yeah, again, up until Wednesday, we didn't have any concrete information that we felt justified any sort of change in Terrence's status, and so that same decision permeated throughout all the rest of the things that are related to the operation of our basketball program.
Brent, way in the back.
Josh in the back. Have you been told by anybody or any authorities that anyone else is involved, or is this isolated just to Terrence?
I'm only aware of Terrence.
As a leader, how much is it on you in these times to lead your program, lead the DIA, and how much do you take onus of that to be that leader?
I think that I stand as the leader of this athletic program day in and day out. You all have been around me in good times and bad times. I've never shied away from that leadership responsibility, and I feel like in these situations in particular, it's necessary for me and for others to demonstrate strong leadership.
Jeremy.
Josh, do you feel like that misconduct policy held up, like it did its job that you felt it needed to do?
I do, and again, I talk with Ryan Squire today, I asked him how many times he thought we had implemented the misconduct policy and used the conduct panel, and he estimated a dozen times over the last 7 or 8 years. So this is not something this is something that we have used on numerous occasions. We have great experience using the policy, and I think it has held up well over time, and I think it served us well in this instance as well.
Go back to Matt here in the front.
Josh, I'd like to ask you about the complaint that was filed in district court on December 5th. Is it, again, I want to ask, is it your understanding that yesterday was the first day you had seen that at all?
That was the first day I'd seen it, yes.
Would that document have being presented shortly after it had been filed? Would that have changed the dynamic of how quickly the conduct policy would have been enacted at that point?
I'm not following your question. I'm sorry.
Would you, knowing that document existed, let's say after like December 6th, immediately after it was filed, would that have changed the timeline of which you would have acted and the policy would have kicked in?
Well, that requires some speculation. I don't know that I'm comfortable getting into that, but I will say that clearly it's a charging document. It's a document that contains strong allegations against one of our student athletes. Initiates a formal court proceeding, and so a document like that certainly would be very relevant to our consideration and to the implementation of the policy.
Go to Derek and then back to Scott.
Josh, as you mentioned, the conduct panel is independent of you, independent of your department, but based on your knowledge of it and the process, what would go into a decision of playing time without legal resolution?
The conduct panel will be presented with the information that we have available to us at the moment, and ultimately they'll be empowered to consider a number of different factors in determining what serves the best interests of our community, our students, and of course our university.
As a follow-up, do you know when the panel will convene and when a decision might be revealed?
I don't want to get into details about when that might occur.
Go to Robert here in the middle.
You mentioned how this came down on the afternoon of the 27th. I think some of the perception, the video, for example, that came out at 8 p.m. on that evening, showing the team exchanging gifts, Terrence giving gifts to his teammates. I think there's a perception, if the school already knew that this was going down, why are videos promoting things like that going out? Can you respond to that?
Well, I think Joey perhaps kind of touched on that already. I think I generally addressed it. Until we had information that triggered our policy, then Terrence's status with the program was unchanged. And in situations like that, we weren't in a position to provide directive to some of the younger members on our staff who had no idea that these things were happening to change course relative to how we're promoting the basketball program.
Scott here in the front row.
Yes, Josh, in the official release, you mentioned that you rely on the policy and prior experiences to kind of maybe shape the response to the situation. Are there any specific prior experiences here that maybe you went back to as you dealt with this one?
None that I want to discuss with you. Of course, sure. As I mentioned, we've implemented this policy numerous times over the years. We've convened the conduct panel multiple times over the years, and so each time we've done that, we have learned from that experience, and we have built some level of precedent in how we intend to implement the policy going forward.
Go ahead, Jeremy.
Josh, I don't know if you can answer this, but what is his status with the university? And just to be clear, what would have to happen for him to return to the team?
The status with the university, I'm not positioned to speak to. That's not an area that's sort of within my purview. In terms of what would have to happen in order for him to return to the team, I don't want to speculate about that sitting here today. Ultimately, one of two things would have to happen. Either the conduct panel would have to vote to return him to status during this interim period, or there would be some resolution of the case in the legal system that would open the door for his return.
Go to Doug and then back to Joey.
Just to, John, over here, just to follow up on the first question that I asked you. You did say that in September you had an initial conversation with Terrence and he was forthcoming, was the word. What was he forthcoming about? And did it match the documents that you received?
He talked about the activities that he engaged in over the course of the weekend in Lawrence.
To Joey?
Judge, just for clarity, the suspensions, he lost access to all facilities during the suspension?
No, he's not. He is suspended from team activities, and so he is still a scholarship student athlete at the University of Illinois. He still has access to certain support services and personnel, but he will not be engaged with the team in any manner.
Brad wrote too.
Josh, how do you balance, obviously, this situation with supporting Terrence as one of your student athletes, but also understanding the severity or seriousness of the allegations as he goes through this process?
I think that there is a really delicate balance there, clearly. We have known Terrence for 2 years. We care deeply about him, but we also recognize that the situation is incredibly serious. The nature of the allegations is serious, and we have to treat it as such. And so, as I mentioned at the outset, we have to make sure that we are sending the appropriate message in terms of how we will approach sexual misconduct as an athletic program, as a university, while at the same time honoring Terrence's due process rights, his presumption of innocence. And so it's a delicate balance, but it's one that is very important for us to strike.
Matt, again.
Josh, Mike, again, with the student conduct policy, is my understanding correctly that you can now then override the 3-person panel, and then therefore the next step would then be the chancellor can override your decision? Do I have that correct?
No, the 3-person panel is not advisory. They are a deciding body, and so the decision that I make, again in consultation with the chancellor's office and others, is do we have information that is sufficient to trigger the policy? Once the answer to that is yes, then the immediate suspension begins. That immediate suspension should last no more than 48 hours before it's reviewed by the conduct panel. At that point, the conduct panel will make a decision about whether the suspension should stand or not, and the decision of the conduct panel in that instance is final.
Follow-up unrelated is, have you inquired through University of Illinois PD, through Lawrence PD, why there was a 22-day window in which Terrence was charged and then a warrant was made out for his arrest?
I have not.
Okay, we'll go ahead and wrap. This is our last one then with Derek.
On the note of a decision being final, is that to push forward an indefinite suspension, or will it have a definite timeline as far as that decision?
The conduct panel can reconvene at any time if new information were to be received or is forthcoming. And again, bear in mind that the conduct panel's decision relates to this interim period of time. And so if at some point there is resolution, again, to the legal process, then the responsibility for determining the student athlete's long-term status within the program falls back to me as the athletic director. And so the conduct panel deals only with these short-term interim situations. I will deal with long-term status once these matters are resolved through their outside processes.
Okay, that'll wrap us up. Thank you, Josh.
Thank you, everybody.
Transition to the game.